Pause. Fabulous. First of all, just to introduce myself, for those of you who do not know me, my name is Maria Papayawanu-Duick. However, since everyone here is my friend, you may call me Maria. I'm not going to make y'all call me Ms. Papayawanu-Duick. That's just for people I don't like. Thank you for everyone for your attendance in our final webinar this year in our series Educate, Engage, and Empower. This is our last one for 2021. We've had some incredible guests and we're ending it off with a big bang because I'm so excited to welcome Dr. Douglas Elliott. Some of you may or may not know him or be familiar with him. Dr. Elliott is a partner in Cambridge LLP. He received his BA from the University of Western Ontario in 1979, his LLB from the University of Toronto in 1982, and was called to the bar in 84. The Law Society certified him as a specialist in civil litigation in 2003 and awarded him the Law Society Medal in 2010. His practice encompasses a wide range of complex business litigation, including cross-border litigation, alternative dispute resolution, estates, and trust laws. Dr. Elliott is well known for his work on landmark constitutional cases such as same-sex marriage and is also a leader in the field of class actions. He has been counsel in class actions involving some of the largest recoveries against the Crown in Canada. Dr. Elliott won the largest Canadian class action trial judgment valued at $50 million in an action brought by a group of gay and lesbian Canadians seeking CPP survivors' pensions against the federal government in Hislop versus Canada. He played a key role in the national hepatitis C team that secured a $1.5 billion settlement from the federal and provincial governments in Parsons v. Canada, one of the largest settlements in Canadian class action history. In addition to numerous awards for his social justice work, Dr. Elliott has been recognized as a leading expert on public law, both class actions and charter litigation, and as one of the best class action lawyers in Canada by the best lawyers in Canada. He is also listed in Canadian Who's Who, published by the University of Toronto Press. If that's not enough, he actually has spare time. So no one can say I don't have time, because Dr. Elliott is an avid gardener, reader, and swimmer with a passion for history and genealogy. I will never say I'm too busy again. Some of you may know Dr. Elliott and his firm have been retained by the Canadian Vaping Association, CVA, to challenge regulatory changes that have or may occur when it comes to vaping that will prohibit and drastically reduce access of these products for Canadians across our country. They are proactively preparing to hold the Canadian government accountable should a flavor restriction happen and at the federal level. Additionally, they have also been retained by plaintiffs in New Brunswick to fight the existing provincial flavor ban. Thank you. So I want to welcome Dr. Elliott to our webinar today. For all the participants, please share your questions in the Q&A section of the Zoom. I'm going to monitor all of that and be able to ask those questions, and we'll work hard at answering all the questions that you may have within the time that we have. And now, without further ado, I will put the spotlight and pass the camera on to Dr. Elliott. I think you're
sorry, the old trick of Zoom, right? You're on mute. So thank you, Maria. I'm glad I'm allowed to call you Maria, because I think I would have some difficulty wrapping my Anglo-Saxon tongue around your surname, but I do appreciate your kind invitation. I'm glad we were able to do this. And I want to thank everyone who's joining us this evening to learn more about the Charter and its impact on vaping. So let's just talk a little bit about the Canadian Charter of Rights and Freedoms and how it's structured, and what the relevant sections are that may be important in looking at the efforts of governments to restrict access to vaping products. And I will touch on some of the evidence that I think is important in these cases. I'll tell you a little bit about what's going on in New Brunswick and what is going on at the federal level. And then I will certainly open it up to questions. Before I do that, I wanted to preface my remarks by talking a little bit about where I come from on this issue, because I think we all have a personal perspective to bring to bear on these important policy questions. You've heard a little bit about my experience. One of the things that has been very formative in my life has been the AIDS epidemic and the response to the AIDS epidemic. And through the efforts of the LGBT community and other allied AIDS activists over the years, there's been really a sea change in the way public health has responded to issues. And in particular, we have seen an emphasis placed on individual choice and on harm reduction. When I first got involved in the fight against AIDS back in 1983, the idea that there would be supervised injection drug sites for injection drug users in Canada in order to reduce the risk of HIV transmission to injection drug users would have been inconceivable. People would have thought you were totally crazy and that no one would ever agree to any such outlandish idea because it would promote the use of heroin and other deadly drugs. Well, of course, now it is well accepted that harm reduction is a better option and that the supervised injection sites are socially desirable and good for both individual health and public health. And now it's very clear, and I think the AIDS movement has a lot to do with it, that harm reduction is really the cornerstone of modern public health policy. And I did spend some time as a volunteer on the Science Advisory Board to the Minister of Health at the federal level at the time. So I've had some insight into policy making at the federal level up close and personal. I had more spare time back then, Maria. So with that kind of personal background out of the way, and I should add to that, by the way, I've never smoked tobacco and I am not a vapor. So I don't come to this with a passion about vaping because it's helped me stop smoking like so many of you have experienced, but rather I come to this from the perspective of someone who believes that it's really important to respect rights, to empower individuals, and to focus public health policy on harm reduction as the key measure in implementing reduction in public health risks, as opposed to the old-fashioned abstinence approach, which I think has been thoroughly discredited as counterproductive and indeed harmful. So let's talk about the law now for a moment. Enough about me, let's talk about the law. So the Canadian Charter of Rights and Freedoms next year in April will be 40 years old. It was a big step forward for our country at the time because it really made us independent from the United Kingdom and gave us control over our constitution for the first time in our history as a country. But as part of that process, the Constitution embedded a Charter of Rights and Freedoms so that all Canadians had certain rights and freedoms that were recognized in this Charter of Rights and Freedoms, subject to certain limits contained in Section 1. And I will come back to Section 1 in a moment. But just bear in mind, as we're having this discussion, that none of the rights in the Canadian Charter of Rights and Freedoms are absolute. And we also have a principle under the Charter that we do not allow one charter right to trump another charter right. There is no hierarchy of rights in the Canadian Charter of Rights and Freedoms. So I'm not really going to spend much time on the issues that have come up in Quebec, for example, about packaging and freedom of expression limits. I'm going to focus on the more pressing questions related to flavor bans and other more direct attacks on the accessibility to vaping products in Canada. So in that context, there are two really important sections of the Canadian Charter of Rights and Freedoms. The first is Section 7, and Section 7 is often called the liberty interest. Section 7 guarantees us all the right to life, liberty, and security of the person, and not to be deprived of those rights, except in accordance with the principles of fundamental justice. The Canadian courts have interpreted Section 7 to mean, among other things, that our rights to our bodily integrity are protected by Section 7, and our right to make important personal choices. And those there's a variety of important personal choices we make in our life, the right to get married, for example, but of course, rights about our health are some of the most important rights that we have, that are very important to be made by the individual, except in special circumstances, of course. Sometimes people lack the mental capacity to make the decision, either permanently or temporarily, or in the case of young children, they lack the capacity to make those decisions. But we're talking about adults who are mentally competent here. Adults who are mentally competent have the right to make important personal choices. I can choose to smoke or not to smoke. I can choose to drink alcohol or not to drink alcohol. I can choose to take anti-cholesterol medication for my cholesterol problem, or I can decline to take it. Of course, the one that's very in the news these days is vaccination. I have the right to choose to be vaccinated, and I have the right to choose not to be vaccinated under Section 7. So that one is obviously very important, because most of the people who vape, let's just say that even if you were vaping because you like the taste or for your own amusement, that would be protected under Section 7 to some extent. However, for the vast majority of vapers, they're vaping because they are addicted to nicotine and they want a safer nicotine delivery system. So it is a harm reduction choice. It is a health choice that they are making. And while some people might think it would be better if they stopped smoking and stopped vaping altogether, just as you have the right to smoke, you have the right to vape, and you have the right to choose vaping as a harm reduction technique as opposed to smoking cessation altogether. That is, in my view, clearly respected and protected by Section 7 of the Charter of Rights and Freedoms, subject to Section 1, and we'll come back to Section 1 in a moment. The other one that is important is Section 15. And Section 15.1, there's Section 15.1 and Section 15.2, but Section 15.1 is the one that we're most concerned with here. And Section 15.1 is the equality guarantee. Now, the restrictions on vaping, when they prevent people from access to vaping products, there's a pretty clear infringement of Section 7, because you're interfering with someone's personal choices, important personal choices about their health. That's a pretty direct infringement of Section 7. But where is the impact on equality? Everyone is subject to the same restrictions. There's no special rules that say that gay people get access to flavors and straight people don't, or that Indigenous people get access to flavors and non-Indigenous people don't. So where is the Section 15 problem? Well, here we need to talk about discriminatory impact or indirect discrimination. The violation of Section 7 is a direct violation. The violation in Section 15 is an indirect violation. It's indirect discrimination. And it is indirect discrimination because the same ban has a differential impact. If you think about it, for example, if I put steps in front of my commercial building, I'm treating all people equally. However, those steps have a different impact on someone in a wheelchair than they have on someone who does not require the use of a wheelchair. So that is, those steps have a discriminatory impact on the person in a wheelchair. So how does that play out in the context of vaping? Well, it's relevant because, not so much because of vaping, but because of patterns of nicotine addiction. The evidence is very clear that certain marginalized communities are much more prone to tobacco smoking and to the resulting nicotine addiction than other communities. And the ones that come up very frequently are Indigenous people, LGBT people, and people who are mentally ill. Of course, it's long been known that nicotine has been used to reduce anxiety in people, but it's a well-known phenomenon. I was on the Consent and Capacity Board in Ontario, which is our mental health tribunal, for 10 years. And I soon realized that people with serious mental illnesses, such as schizophrenia or bipolar disorder, were almost universally very heavy tobacco smokers. It was extremely common. So it's really important for those people to get access to vaping as an alternative to reduce the risk of the harms caused by tobacco smoking. Similarly, we know that in the LGBT community, there is a higher incidence of tobacco smoking. That's been well established. I confess, even though I'm a gay man myself, I wasn't that aware of that phenomenon until I started getting involved in the vaping issue. But it certainly makes sense to me. For example, for historic cultural reasons, gay men used to typically gather in bars, and in the old days, drinking and smoking went together like a horse and carriage. And so it's not entirely surprising that, especially in older gay men, people of my generation, that there would be a higher incidence of smoking. And of course, Indigenous people, well, they've been using tobacco for a long time, but the smoking is much higher in the Indigenous communities than non-Indigenous communities. And of course, part of that has to do with the fact that there are higher smoking rates in people who have a reduced socioeconomic status than others. So that you have to allow for that too. But anyway, these are the ones that we are most focused on. There may be other groups that have higher rates of tobacco smoking, but these are the ones that are perhaps the most significant. And these are all groups who have been recognized as having been unfairly treated by Canadian laws in the past and by Canadian policies, and have had successful cases in our courts arguing about the differential impact of the law. So another example I can use of how differential impact works, when I was arguing the same-sex marriage case, the governments and some of the churches put forward the argument that the right to marry did not discriminate against me as a gay man because I had the same right to marry a woman that a straight man did. And that's true. We were treated equally, but you can see immediately, if you think about it, what an absurd proposition that is, because of course, as a gay man, I wanted to marry a man. I didn't want to marry a woman. And so the law that restricted my choice to a woman had a differential impact on me, a discriminatory impact based on my sexual orientation. So those are the two main provisions that are going to be deployed are being deployed in New Brunswick. I'll come to New Brunswick in a moment. That are being deployed in New Brunswick and will be deployed against the federal government should they proceed with their ill-conceived flavor ban next year. The rights under Section 7 and Section 15, like the rights under the Charter in general, are all subject to the override that is contained in Section 1. And Section 1 says that the rights and freedoms in the Canadian Charter of Rights and Freedoms are subject to the reasonable limits that are demonstrably justified in a free and democratic society. So under Section 7 and Section 15, the onus lies on the person who's asserting a rights infringement to prove in a court of law that those rights have been infringed. Once that has been done, the onus then shifts to the governments to show that the rights violation is justified under Section 1. And that justification, it consists of two main aspects. The first is that it has to be demonstrably justified. That means there has to be proof that the restriction is valid. Some of you may recall that when the Harper government was in power, they didn't like supervised injection sites, and the Harper government refused to renew the license of a very well-known site in Vancouver, and they were taken to court. And Prime Minister Harper said the reason that they were not going to allow this supervised injection drug site is because he was the Prime Minister and was elected by the people of Canada, and he did not want supervised injection drug sites. And that was reason enough because he said so. Well, that doesn't work in a court of law because we don't operate in a dictatorship where the Prime Minister or the Premier tells us what to do. If their actions are violating the rights that we have under the Charter, they have to provide evidence, which in a case like the supervised injection drug site case meant you needed to have proof of harm. You needed to show that the federal government's argument that crime was going to go up or drug use was going to go up or other problems were going to result, you needed to have proof of that. If that was your personal opinion, that didn't constitute proof. And there was, in fact, no proof in that case at all. In fact, the supervised injection drug sites in those cases had been supported not just by public health, but by the Vancouver police as well. So that's one of the reasons why going to court is really useful, because governments can't rely on BS. They can't rely on political posturing or the popularity of their position. They have to actually put forward evidence to back it up. And the second question is a free and democratic society. And so what a court will do is they'll look at the restriction and they'll see how it compares to the types of restrictions that have been imposed in other jurisdictions. And have other democracies found it necessary to impose such restrictions to achieve valid government objectives? And they do have to be a valid government objective. So for example, in the Big M Drug Mart case many years ago, the Supreme Court of Canada said the promotion of Christianity is not a valid government objective. we don't have a state religion in Canada. And so that can never be a justification for a restriction on freedom in this country. So that's the framework of the law. And how is it unfolding on the ground right now in New Brunswick? And what's happening in New Brunswick will foreshadow, I think, what will happen at the federal level. Well, as you may know, the New Brunswick government brought in a flavor ban, very similar to the flavor ban that had earlier been introduced in Nova Scotia. The flavor ban in Nova Scotia, we have evidence that it has had disastrous effects. It has, of course, been disastrous for the vape shops, most of which are mom and pop shops. But it has been disastrous for those vape shops which were operating in Nova Scotia. It has actually led to an increase in tobacco smoking, not a decrease. And so it appears that what has happened is that there's a lot of people who have gone back to smoking, and there's a lot of underground use of vaping products. Which, of course, the argument that gets used is that they want to protect children, and how they expect children are going to be protected in a black market environment escapes me altogether. I will say, as a gay man, I'm very used to this appeal to the need to protect children with no evidence being trotted out by governments to whip up hysteria when in the absence of any real evidence. So we tried to persuade the New Brunswick government to relent and to negotiate with us about the flavor ban in New Brunswick, but they've taken a hard line and they are insisting on enforcing it. I will make it, I also think it's really important to make clear that they were told in no uncertain terms that the effect of the flavor ban is going to be to put the industry out of business. That even though it still allows the sale of vaping products in theory, by restricting vaping products to tobacco flavor, and as I said, if you say that you're going to restrict the sale of the product to manure flavored vaping fluid, to pretend that you're not actually banning it is ridiculous, because no one's going to use it. So it is, in our argument, tantamount to a complete ban on the product, which is, of course, problematic for a couple of reasons. First of all, it's a very clear infringement of Section 7. Secondly, it will have a negative impact on the marginalized communities under Section 15. It is, from a public policy perspective, completely out of step with our whole approach to harm reduction that we've taken in other circumstances. It's, in fact, quite illogical and absurd, because it amounts to a ban on the sale of vaping products when they have not banned the sale of tobacco itself, which is clearly a far more harmful product. In fact, the New Brunswick government also sells flavored birthday cake flavored vodka and other flavored alcohols that clearly are intended to appeal to a younger market. And they don't seem to have any problem with that. They seem to be singling out vaping for these kinds of restrictions that don't apply in any other context, public health context. So that is a problem. And the final problem is another legal one, and that has to do with the fact that provinces don't have the right to create crimes. The criminal law in our Canadian Constitution is reserved for the federal government. So it is when a product is harmful, poisonous, deadly, It is up to the federal government to ban it under the federal criminal law power. The provinces do not have the right to create crimes. So we will be arguing in the New Brunswick case that the ban on flavors is tantamount to a ban on vaping, which is tantamount to criminalizing vaping, and it is an invasion of federal jurisdiction. And I think actually the legislative record will show this, that the provinces have all been in discussion with the federal government about the proposed federal flavor ban, and they simply got tired of waiting for the feds to do something. And under pressure from the anti-vaping hysterics, they decided to introduce provincial bans and take their chances on legal challenges. And so, of course, we have launched a legal challenge in New Brunswick. We are in the process of filing a range of expert evidence, which I think is extremely compelling about the legal issues and scientific issues that I've outlined. We have, of course, stressed the British model where vaping is being promoted as a harm reduction technique. And we've also pointed out to the court the failure of flavor bans as a policy choice in Nova Scotia and also in San Francisco. Some of you may be familiar with the San Francisco flavor ban. This will set the stage for what will happen in next year if the federal government proceeds with its flavor ban, because we fully expect that there will be a legal challenge similar to the one in New Brunswick. The only difference between the attack that will be made on any federal flavor ban and the New Brunswick flavor ban is that obviously we cannot assert that the federal government is invading provincial jurisdiction by invoking a flavor ban. They clearly have the right to ban products as part of the federal government's criminal law power. The question really is going to be whether a flavor ban in this context is not available to the federal government because it violates the Charter of Rights and Freedoms. And we believe that it does. But we are putting considerable resources, legal and financial, into the fight in New Brunswick because it is kind of the dress rehearsal for a later fight that we may have at the federal level. I believe that the scientific evidence is overwhelming that vaping is a safer alternative to tobacco smoking, that a abstinence-based approach, which is what a flavor ban really amounts to, is nonsensical, counterproductive, and harmful, and that it will not achieve its objectives. And in fact, as we have seen in Nova Scotia, it will actually lead to an increase in tobacco smoking and an increase in black market sales to children, which is exactly the opposite of what the government claims it's going to achieve through this flavor ban in New Brunswick. At the end of the case, our objective is to achieve a declaration that the legislation is constitutionally invalid. And if that is the case, we anticipate it will be appealed by the New Brunswick government to the New Brunswick Court of Appeal, and it could ultimately end up in the Supreme Court of Canada. On that note, I will mention something that I think is very important for vapers, and that is we have already been approached in New Brunswick by a group of physicians that wants to intervene in support of the New Brunswick government. Interveners, they are called, are quite common in constitutional cases. I've often represented interveners. In my experience, they can have a profound impact on the outcome of a case. I think it's going to be very important moving forward that people in the vaping community don't just count on the righteousness of their cause, but they reach out to these other affected communities and some of them notably, I mean, the mentally ill, not so much, but Indigenous people and LGBT people have pretty impressive track records in asserting their rights and winning their rights in our courts. I think it's going to be very important if we're going to prevail in the end for vapors to reach out to the Indigenous vapors and the LGBT vapors and the Indigenous organizations who are not vaping organizations and the LGBT organizations that are not vaping organization, and to seek their support for your cause, because those organizations will get the attention of the court and they will get the attention of the politicians, and they will serve as an important counterweight to some of the hysterical doctors and to organizations like the Canadian Cancer Society that's on the wrong side of this issue, in my humble opinion. So those are my, that's kind of my sweeping overview of the charter and the current state of play in New Brunswick and at the federal level. And I'm happy to take questions now.
Okay, we've got questions in the Q&A. First of all, thank you. That was like, I was so enjoyable to hear, and it just kind of made my brain just work a little bit harder, because you gave a different perspective. Because I think for most of us, we're always used to hearing about Section 7, for me, almost a decade, but now understanding a little bit more and seeing the complexity and the levels of it. We have some questions here. A question that's been asked a couple of times is about how provincial governments are taking this abstinence only approach. Like you said, that they're creating a crime, and they do that.
Yeah, they are. If they take an abstinence approach and they ban a product, if you ban a product, that's criminalizing the sale of that product, that's criminalizing that activity, and creating a crime is only something that the federal government can do. Provinces are not allowed to create crimes. So that is why they haven't outright banned the sale of vaping products altogether. They've tried to disguise the fact that they're banning vaping products by saying that they will allow them as long as they are only, as I say, manure flavored or tobacco flavored, knowing that no one will buy them if they taste like that. And so it is tantamount to a ban. And I think the fact that they know that they are overstepping their authority is made apparent by the fact that they haven't actually banned it. They've just effectively banned it and tried to disguise that that's what they're up to.
Thank you. I think we all thought that, but you kind of said it much better than the rest of us. I'm sorry. I think I'm fangirling a little bit too much, but
no, that's okay. And look, Maria, as I say in the New Brunswick case, just to make it perfectly clear, we told them and we said, look, in case you're making a terrible mistake and you don't realize that this will have the effect of banning it, we're telling you that that's the case. So if you're making a mistake, stop now. Well, they didn't stop, did they?
No, they didn't. They doubled down.
They did indeed. They did indeed double down.
We have a couple of physicians in our some of our oh my God, the people watching.
Yes.
And one of them wants to know, who are the New Brunswick physicians intervening for the flavor ban? Are you allowed to share that?
They have not intervened yet. They've simply sent us a letter, and it was the New Brunswick Medical Society that wrote to us.
Okay.
So it's the licensing body for New Brunswick doctors, as I understand it. And they were apparently consulted about the flavor ban.
Interesting. Jackie, who is, as she refers to herself, a pre-senior.
I'm a full-blown senior.
There's a pre-senior, but she has been so active in being a consumer I call her an activist. She talks about all these child-proof stuff that is happening. And her question is, Health Canada enforced child-resistant tanks, despite all bottles of e-liquid having child-proof tops, which hold 30 to 60 mils of e-liquids. As a pre senior, she's not able to manage to use these tanks. She doesn't like the pod system, and that's not her. Is Health Canada, by this enforcement, limiting and if not totally neglecting the needs of those with limited fine motor function or those of a certain age?
That's an excellent question. And that issue has not been raised thus far, but it's something I will take back to the Canadian Vaping Association, because definitely putting a restriction that is otherwise reasonable, for example, the Canadian Vaping Association has always taken the position that it's reasonable to have some restrictions on sales to children. There's not an intention to try and promote sales to children. But if these particular products don't really offer an option to people who have physical disabilities or have an adverse effect on seniors like me, who are not as agile as younger folk like you, Maria, I think there's an argument to be made there that there's a differential impact. So I really appreciate that question. I will take that back to the CBA.
Fabulous. I can tell you from when I'm working, there are quite a group of people where we have to pre-open all the bottles for them because they are not able to open their bottles easily. They have a lot of difficulty with them. So that's something.
I listen, if I was a vapor, I would probably have that problem because I suffer from something called benign inherent tremor. I have shaky hands. It's a genetic quirk, and I've always had that. So I would probably have that problem myself.
Like, we do what we can, right? We need to help everybody. So this is from Janine Timmons. Considering there have been disastrous effects from the flavor ban in Nova Scotia, how can Health Canada proceed with federal regs banning flavors?
Well, they shouldn't. That's clear. And believe me, we are going to be making sure that they get all of the evidence that we have mounted. And it's just coming in now, right? I mean, it is just coming in now, and there haven't been any structured scientific studies, but the evidence that we do have, the statistics we have, for example, about the increase in tobacco sales, it's undeniable. And so I'm hoping that we are going to be able to get the government to think again. We do have a new health minister. That helps. When you have a new guy at the top, you got a chance for a second look. The real problem here, of course, is that I think the bureaucrats at Tunney's Pasture are totally sold on the idea that vaping is evil and vaping is the same as smoking, both of which are ludicrous concepts. I mean, it's, as far as I'm concerned, I would put it in the category of conspiracy theories. It's junk science. It doesn't stand up to scrutiny, but you have to sometimes challenge those accepted notions. You know, they just as at one time the federal government used to have a policy that that banned gay people from working for the federal government because they thought we were a threat to national security, and there was no scientific proof of that either. But yet they carried that policy on for decades without any proof because everyone agreed that that was the truth. So sometimes you have to speak truth to power, and you have to challenge these received notions. And it's particularly important in this case, because even though the public health bureaucracy has bought this idea, and some of the media have bought it as well, every time I hear CBC radio doing a story on this, I want to throw my radio out the window. But the politicians are supposed to listen to the people, and they're supposed to listen to the evidence, and they're in charge of the bureaucrats. And so you do have a chance to get them on side and get them to do the right thing. And I think we have a chance to present this evidence to the new health minister and to his staff and to try and get them on side. And I think the way to do that is to get the vapors talking to their local MPs and getting them on side, and also getting, as I said, these allied organizations, get the gay organizations talking to the MPs who are sympathetic to gay issues, get the Indigenous organizations talking to the Indigenous MPs, the MPs who care about Indigenous issues, and explaining about the impact on their groups of this legislation. And then you will start getting allies in the caucus, and they'll start leaning on the minister.
Thank you. That is, like, right now, I was just like running a list through my head of people I can reach out to. This one, I think the person asking this question has a legal background. So
Okay.
a lot of research that I've seen about vaping is mostly about the science/health. Is there much evidence for the Section 15 argument to meet the Oakes test, socioeconomic impacts of a flavor ban?
Yes, so the Oakes test, that's referring to Section 1. That is the famous case where they decided how you analyze whether something meets the test under Section 1. And there's a few things that you look at. What is the purpose of the legislation? And is the measure minimally impairing of the rights? And is it proportionate? The question in the context of vaping has not come up, but I believe that we have a pretty compelling argument that there is no justification for this, that the government is going to be able to amount. We haven't seen the New Brunswick government's evidence yet that they're going to rely on in support of the Oakes test to say why this is why this is demonstrably justified. I think they're going to have a very difficult time because the evidence is pretty weak. There is they did get some preliminary evidence at one point. For years, they've been making this argument that the flavors attract children. And there was, for a brief period of time, there was a little bump in the young people who were vaping. But the problem with that is it's very ambiguous evidence, and there's no proof linking that to flavors at all. It's pure speculation. There haven't been any, normally what you want is some kind of controlled studies that would show that this is what is going on, or at least some reliable surveys. There's plenty of evidence to suggest that even that little bump that took place at one point can be just as easily explained by young people who were just experimenting at that particular time because the youth vaping has gone down again. It was a bit of a hiccup. And it's certainly, there's nothing to suggest that the flavor ban has anything to do with it, that the introduction of flavors increases the amount of vaping by youth, or that the ban on flavors decreases the amount of vaping on youth. The one thing we do know is that a ban on flavors increases the amount of tobacco smoking by youth. That much is for sure. And that is exactly what they are supposedly trying to prevent.
Okay, there are a couple of questions. They're all kind of on the same theme, so I'll lump it all together.
Sure.
Currently, right now, if a pharmaceutical company would like to sell a vaping product, they can make a prescription. They can go through that big process that we keep hearing about that is very expensive, and they can label it as a smoking cessation product.
Right.
There is a little bit of a movement when we're seeing some, I like to call them the anti-vaping groups, and the quiet ones and the loud ones, trying to push for the vaping to be removed as a consumer product and solely being put in as a pharma product. And I think what the question is, would that be considered limiting access to vaping products? Because, I'm old too, and I have to go get my prescription. It takes almost forever. And I can't imagine a pharmacy being able to help me like a vape shop can. So I think that's a little bit of a concern for a lot of people as well.
Right. So I think that would definitely be restricted, because of course, what you have to show then is that it is going to be effective for smoking cessation, and also that it is going to go through the drug review process, with which I'm extremely familiar from my work on the Science Advisory Board to Health Canada. I think that that is just a diversionary tactic. Again, this is like what it's like reducing the flavors to just tobacco. It's trying to appear to be reasonable, that you're not engaging in an outright ban. You're giving people an option when you're not really giving people an option at all. Because what the point of vaping for a lot of people is not smoking cessation, it's harm reduction. There are some vapors who still smoke occasionally, or they will go through a process where they'll gradually start cutting back on their smoking until they rely on vaping. So it is a harm reduction technique. It is not a smoking cessation guaranteed device. Although, let's be clear, it's way more effective at reducing smoking than Nicorettes or patches or any of the other products. The evidence is overwhelming that it is the most effective way to reduce smoking, period. Better than anything else. And yet you do not see these hysterical anti-nicotine people campaigning against Nicorettes. Why not? I don't get it. Well, it's because vaping is a convenient target, I think. It's kind of the flavor of the month for the abstinence crowd. They seem to be on that. That's where the abstinence bandwagon has headed, is into vaping territory. And it's time to take the wheels off that abstinence bandwagon again. We did it in the AIDS movement when they were telling us, gay men shouldn't have sex, and injection drug users shouldn't use drugs, and Haitians shouldn't be Haitians, and all the other silly arguments that were made. And no one today, who today would say, oh, we're not going to distribute condoms, we just want people to stop having sex? No one would say that. They'd be laughed out of the room. And yet the same public health officials who will support distributing condoms and who will support safe injection sites are saying that people shouldn't be allowed to vape. It boggles my mind, I must say. It just boggles my mind.
It boggles my mind too. As someone who believes in harm reduction, I believe in harm reduction for everyone and for everyone's addiction, for everyone's safety. And I do believe one cigarette replaced by vaping is equal to harm reduction, because there is no weight on it. Like, that's the way harm reduction has been presented to me during my entire life. Well, not really. It only started halfway through my life, because, I think it came in hot in the late 90s, early 2000s for addiction. We have 3 minutes left, but we have lots of questions.
Pick one or two and we'll do them.
I'll pick one or two. Yes. What is the argument to prevent the government from limiting the flavors to tobacco, mint, and menthol? Last week, we had a webinar, and Health Canada mentioned that they're not banning vaping, but limiting flavors.
Yes, well, the point is that any restriction on choice is an infringement of Section 7 and Section 15. So it's not up to us to justify why we want more flavors. It's up to them to justify why we shouldn't have. I'm overweight and they let me eat salt and vinegar potato chips and ketchup flavored potato chips and all kinds of ridiculous, unsafe products. Why? Because I'm a grown-up and I get to choose the flavor of the potato chips that I eat. So I think it's a wrong-headed argument. And the second point is that what we have seen is that nobody wants tobacco-flavored fluid. As I say, they might as well call it manure-flavored fluid. Nobody wants it. The people who are vaping because they don't want to taste tobacco anymore. They want to taste something else. We have very convincing evidence in our New Brunswick case that the flavor limitations are really tantamount to a ban, because the only flavors they are permitting are flavors that nobody wants.
I totally agreed. Like, I mean, I'm tired of hearing mature flavors. Like, I don't know. Is that discriminatory to call me mature? Does that make me sound old?
No, but I mean, the reality is, what about the birthday cake flavored vodka? Go to your local liquor store and see the cherry brandy and the orange liqueur and all the different flavors. Look at all those coolers, Mike's Hard Lemonade.
The party.
We shouldn't allow, well, on their theory, we should only allow, coffee flavored vodka, because that's a mature taste, and we shouldn't allow orange flavored vodka or cherry flavored vodka because that's aimed at children. Well, however, the reality is adults get to choose.
Yeah, but you know what? The hot drink right now are espresso martinis, by the way. So
and I love Kahlua, so it's okay.
Okay, our last question here. For the federal, is there a specific threshold or precedent for the requirement of burden of proof of harm in relation to Section 7, like the Harper example you gave for safe injection site, that could have allowed Harper to proceed?
Yes. So what you have to show is that there is scientific evidence that the measure that you're using is one of the options to reduce harm. It doesn't have to be the best option. It doesn't have to be the only option, but it has to actually achieve the effect that you are claiming. You can't just say that it does. You have to produce evidence that it does. And that's the problem I think the New Brunswick government and the federal government have, is that the public health officials have theories and opinions and hunches, but they have no proof. And they know they have no proof.
Thank you. We're right at 7:31. All I see are thank yous. You are amazing. Thank you so much. This was an excellent webinar. There are so many wishes of gratitude to you. And I just want to say thank you very much for taking time from your busy day. And I so appreciate it, because this is sort of obviously your gardening or genealogy research. I really appreciate it. This has been enlightening. And I know that every single one of our attendees have learned something new. And I hope, and I believe that everyone is empowered to speak up like you suggested, and to talk with the minister. Well, we have two Minister of Health, so whichever one kind of gets this file.
And don't forget your local member of parliament. Please don't forget your local member of parliament. Find out who your local member of parliament is. Doesn't matter what party they belong to. Reach out to them and educate them about this issue.
And we also have a petition out right now, because the last one kind of died with the government. So we're aiming to get another 16,000 on that one, just so we can so people know this is a serious issue. Again, Dr. Elliott, thank you so much from me, Rights for Vapors, and everyone. I hope you have a wonderful holiday season. May 2022 be full of joy and surprises that just add delight and move you forward in life. So thank you.
Thank you very much. So onward to victory in New Brunswick.
Onward to victory in New Brunswick. Thank you, everybody. And good night.
Happy holidays, everyone.
Thank you, everybody, for attending. I hope everyone enjoyed it. And I'm very grateful for everyone that showed up. We are going to have this, hopefully I figured out how to save it. And that was just, if you're not empowered after this, I swear, what a great way to end it. We had the best guests. I just want to thank everybody at the team at the Canadian Vaping Association for helping me secure this interview. That means a lot. Everything we do for vaping in Canada to ensure that we continue to have access is a team effort. Every single consumer, every single shop owner, every single supporter of harm reduction when it comes to tobacco. This is a collective effort of all of us. So thank you. Thank you. Thank you. Sign the petition and get that message out there. Share it with friends and family. Let's make sure that this is heard on the floor.